We're recording this in the first week of April, and the US Patent and Trademark Office just made some important changes for trademark filers, applicants, and registrants in response to the COVID-19 crisis. I want to summarize with you and tell you a little bit about them today. And in the description for this, you will see a link where you can read in more detail on my blog and read the USPTO's full notice. So the big CARES Act bill that was signed into law by the president at the end of March after passage by the Congress included a provision in section 12,004 that gave the USPTO's director authority to extend deadlines as a result of the coronavirus COVID-19 crisis. On March 31st, the USPTO director released the details on what that meant for trademark applicants and registrants and also for patent filers. We're only going to discuss the trademark side here because I have not even reviewed the patent side, as it doesn't affect my practice and my clients. Top level, the important details you need to know is that there are extensions available for deadlines due between March 27th and April 30th at the Trademark Office for trademark filers, but those extensions are not automatic, and there's some steps that filers will need to go through. The USPTO is currently still operating at full capacity, basically, although there are no in-person meetings or hearings for the foreseeable future. In fact, even appeals hearings are now only by video or other meetings by phone. I had a hearing actually scheduled for early this month that has been rescheduled to a video hearing a few weeks from now. So the USPTO is doing a very good job of adapting to these things, and most of the USPTO examiners actually already work remotely from their houses, although there are many other USPTO employees that, to my knowledge, were on site at the USPTO. So I'm sure that there are some adaptations and modifications that need to take place. As I said, the important thing about this notice from the USPTO is that deadlines falling from March 27th through April 30th, 2020, again, perhaps that'll be extended further in the future, and I certainly wouldn't be surprised if it is, that a person may extend those deadlines for essentially any type of USPTO filing, whether it's a response to an office action, an extension of time for submitting evidence use, an actual filing of an allegation of use, a renewal filing, or an extension of time to oppose, or a notice of opposition, or essentially any other filing that's out there can be extended, provided that the applicant submits a request with a statement that the delay in the filing or in the payment for the filing was due to the COVID-19 outbreak, and that the notice lists several reasons, but in essence, I can't imagine any business that wouldn't be able to qualify for it for these reasons, like not being able to access files, an interruption of work, office closures, travel delays, things like that. For deadlines that have been missed already or that are missed as a result of this, the USPTO has waived the fee for a petition to revive. Other fees, of course, that would have been required in the normal course of a trademark filing are still due. And that waiver of the petition to revive fee actually dates back to March 16th, 2020, when the USPTO issued a separate notice on that. The TTAB doesn't have really an extensive policy yet on all these deadlines in TTAB disputes or cases, except they have noted that a request or motion for an extension or reopening will likely be granted if needed during these times, and that deadlines can be extended. Personally, in several cases that I've got going on at the TTAB, I've already requested extensions and received them, or worked with opposing counsel in cases involving multiple parties where we've agreed to delay or extend things as necessary. So to summarize, there are options for trademark applicants that are facing deadlines through the end of April that they're unable to meet. The USPTO is open for business, but these extensions are not automatically granted. You need to file a request for the extension, and I believe that you need to make that filing before the deadline itself arises. So there are some challenges here, and there are some particular wording and language that's going to be needed. It's also going to create some issues with docketing. And the USPTO notice does note that the deadline extension is for 30 days from the prior deadline and not from the date of the extension request. I think that was in the notice. But the notice is complicated, and really until we see some actual filings and actual rulings or responses from the USPTO, we won't have as much guidance as might otherwise be helpful. I will try to keep posting on my social media and on my blog those examples when I see filings that are made requesting the extensions and granting the extensions, so others can benefit from that language. Of course, I hope that you are staying safe during these times. If you have any deadlines that you're facing, either as a counsel and you're unsure, or as an applicant or a registrant and you have questions and you want to discuss it, reach out to me. I've always got free consultations, and I'm really trying to give as much information as I can here to people in an effective way. So if you have more information that you think would be useful also, feel free to share that with me. I'm happy to share that with my audience. Thank you.